Hey there, I hope you're doing great. The topic of discussion is deferred action for parents of Americans and lawful permanent residents, diversifying American assets. You may recognize some, if not all of the logos shown on the screen. Well, they all have one thing in common. They're all companies founded by early generation of immigrants. Introduction to immigration reform. Why is this topic interesting and relevant? Well, there are many reasons. First, the undeniable forces of globalization. With no signs of slowing down, the interconnection of the world is growing. America must continue to adapt in order to remain economically competitive. The less global our workforce, the less competitive our economic performance. Second, the evolution of business culture. Generally speaking, knowledge knows no borders. What Americans bring to the table is a diversified pool of perspectives and methods that keep our business culture relevant. Though regarded as the culture melting pot, U.S. must continue to diversify perspectives since now more than ever, business culture influences are growing abroad. Third, the economic efficiency. As the sense of economic entitlement grows within American borders, it lessens abroad where wealth is generally much harder to come by. The motivation, productivity, and education of individual workers abroad is starting to outperform that of the complacent American. History has shown that the intolerant attitudes ultimately serve no economic purpose. Regardless of its validity, the idea of American exceptionalism is rooted in the collective economic benefit of providing newfound upward mobility to a highly skilled and motivated workforce largely made up of immigrants. For instance, notable companies such as eBay, Google, Pfizer, Goldman Sachs, U.S. Steel, and Procter & Gamble that serve as symbols of American prosperity were founded by immigrants. Reform is a lot more intuitive than dumping money into failed enforcement efforts that yield no return. Lastly, justice. Many of the issues concerning opportunity in immigration can be reduced to a matter of fairness. Training legal issues. Considering the strong backlash from political rivals of the current administration, DAPA could have been a political maneuver to appeal to the growing voter demographic that supports immigration reform. The likely scenario of successful legal challenges to the executive action will not only mobilize the Latino vote in upcoming election. Though the issue of immigration reform is much larger than any one demographic, the political realities must not be ignored. According to an analysis by Gabe Ortiz at AmericanVoice.org, 89% of Latino voters support immigration reform. The issue will be decisive for some campaigns. The USCIS site stated the following: due to a federal court order, USCIS will not begin accepting requests for the expansion of DACA on February 18th as originally planned and has suspended implementation of deferred action for parents of Americans and lawful permanent residents. The court's temporary injunction, issued February 16, does not affect the existing DACA. Individuals may continue to come forward and request an initial grant of DACA or renewal of DACA under the original guidelines. Please check back for updates. The prevailing legal authorities over the U.S. immigration process are the Immigration and Naturalization Act, which sets the limit on the amount of permanent immigrants, and the Immigration Act of 1990, which establishes the visa lottery. Additionally, the executive office and Congress may formulate a limit on refugees. The legal issue we focused on, DAPA. Deferred action for parents of Americans and lawful permanent residents was initiated as an executive action on November 20th, 2014. The policy aims to provide legal relief for what the New York Times estimated as being 5 million unauthorized immigrants in the United States. The focus is one of those who have lived law-abiding lives in the United States since 2010, with the exception of their unlawful residence and entry into the country. Unlike executive orders, executive actions are non-binding guidelines for the direction of policy. Though these actions lack strong authority, they signal a shift towards the implementation of amnesty measures and long-awaited immigration reforms. The effort was blocked by a temporary injunction on February 16, 2015. Scholarly analysis on the issue. Children and Parents, Innocence and Guilt. An article by Hiroshi Matsuyama from a Harvard Law Review explores an emerging concept in the immigration legal reforms movement. It is the concept of membership as brokering. The term is used to characterize an instance where a child who has been given legal relief via recent reforms such as DACA begins to broker transactions that are essential to everyday life on behalf of their parents. Though the parent lacked the freedom from deportation beyond the inconsistent degree of discretion exercised by law enforcement, they can enjoy limited opportunities in a fairly confidential manner. This allows many unauthorized workers to stay and make a living without formal rights. As a result, many current efforts to deport and disrupt stable working families are increasingly characterized of a deadweight loss. Federal deportation policies lack effectiveness when we consider the membership as brokered loophole among other countermeasures. The families lose out as well when their stability and security are at constant risk. This prevents a traditionally well-motivated early generation of immigrants from mobilizing this drive to climb the socioeconomic ladder. On this basis, Mochiruma argues for the progression of parental relief such as the DAPA for pointing out the stabilizing effect that benefits everyone. Marco Maglish's article in the National Law Review addresses the details of the DAPA action while following its legal challenges. He explains the concept of prosecutorial discretion. This is a discretion exercised by the court on whether or not to prosecute someone in violation. When deferring to prosecute an entire category of defendants, a categorical prosecutorial discretion is in effect. He then quotes and explains federal judge Andrew Hainan's rationale for issuing an injunction against the action. Hainan claims that the Department of Homeland Security, at the direction of Secretary J. Johnson, overreached its authority to exercise prosecutorial discretion by rewarding illegal immigrants for breaking the law. This rather radical claim was complemented by the more modest assertion that the DHS did not comply with the Federal Administrative Procedure Act's disclosure requirements when carrying out its action. Mochiruma provides a valid point when mentioning the stability of inclusionary immigration reform. Neither articles call for an overarching dysregulation of the naturalization process. The main focus is utilizing the legal authority and procedures of the federal government to build a more efficient naturalization process. As Maglish points out, deferring legal action has been a long-standing option for authorities from varying political imperatives who wish to exercise discretion over cases of undocumented residents who pose no harm. In fact, sometimes the cost of legal action can outweigh the benefits of deferring. This informal adoption of a legal procedure has been recognized and encoded into the legal framework for a reform through DAPA. Such common ground is hard to come by with controversial issues. As more common ground is discovered, a comprehensive immigration reform can be constructed. Conclusion: it is unreasonable to expect immigration to go unregulated. However, we must question the efficacy of our current regulations when no one seems to gain. Billions of dollars and many years have passed as our current approaches have failed our law enforcement, immigrants, businesses, and national integrity. The legal authority of such efforts will undeniably grow as cosmopolitanism and globalism outpace xenophobia and entitlement. Whether America is ready or not, relief measures such as DAPA will progress from executive action to law, considering that a trend is already firmly in place. This is why we must engineer the legal structure for such policies as soon as possible. Otherwise, American businesses will neglect the human capital that helped build America into the economic power it is today. We must view our workers as assets that need to stay diversified. Thank you so much for your time and have a phenomenal day.